The script focuses on the ongoing legal uncertainty surrounding state-level bans on so-called assault weapons, semi-automatic rifles like the AR-15 and similar firearms, following recent Supreme Court developments. In June 2025, the U.S. Supreme Court declined to review challenges to Maryland's ban in Snope v. Bruen, formerly Bianchi v. Brown, leaving the lower court's upholding of the law in place for now. Justices Alito, Gorsuch, and Thomas would have granted review, with Thomas dissenting strongly and Kavanaugh issuing a statement questioning the lower court's reasoning while suggesting the issue would return in the next term or two. This decision, or rather non-decision, has left many wondering which state bans might fall if the court eventually takes up a similar case and applies the history and tradition test from New York State Rifle and Pistol Association versus Bruen, 2022. Bruen requires gun regulations to be consistent with the nation's historical tradition of firearm regulation, rejecting balancing tests. Imagine you're a law-abiding resident in one of these states. You own a popular semi-automatic rifle for home defense, sport shooting, or hunting, something millions of Americans do every year. Suddenly, a state law classifies it as an assault weapon and bans its possession or future sales. Does the Second Amendment protect it? That's the core question hanging over these laws right now. So here's the question I want to ask you right up front. If the Supreme Court ultimately strikes down these bans, do you think it would make communities safer or less safe? Drop your thoughts in the comments below. I'd genuinely like to hear from you. To understand where we are today, we need to go back to the constitutional foundation. The Second Amendment states, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." For much of American history, this right was understood broadly, but courts rarely tested specific modern restrictions until recent decades. The modern era begins with District of Columbia versus Heller in 2008. There, the Supreme Court held for the first time that the Second Amendment protects an individual right to possess firearms for self-defense in the home, unconnected to militia service. Justice Scalia wrote that the right extends to weapons in common use for lawful purposes, and he noted that prohibitions on dangerous and unusual weapons might be permissible. Importantly, Heller did not invalidate all regulations. It struck down DC's handgun ban and its trigger lock requirement, but left room for long-standing prohibitions like those on felons or in sensitive places. Then came McDonald versus Chicago in 2010, incorporating the right against the states via the 14th Amendment. These cases set the stage, but they didn't directly address semi-automatic rifles. Fast forward to 2022, New York State Rifle and Pistol Association versus Bruen. The court struck down New York's restrictive concealed carry licensing scheme, establishing a new test. Governments must now demonstrate that a modern firearm regulation is consistent with the nation's historical tradition, looking to how the founding generation, and perhaps Reconstruction era, regulated arms. No more means-ends balancing or interest weighing. This shifted the landscape dramatically, leading to hundreds of challenges to gun laws nationwide. In 2024, the court decided United States versus Rahimi, clarifying Bruen somewhat. Rahimi upheld a federal ban on firearm possession by those under domestic violence restraining orders who pose a credible threat. Chief Justice Roberts emphasized that regulations need not have a precise historical twin. They must be relevantly similar in why and how they burden the right. Historical surety laws, requiring bonds from those threatening violence, and going armed laws, prohibiting carrying to terrorize, showed a tradition of disarming dangerous individuals temporarily after individualized findings. Rahimi reassured some that Bruen isn't a free-for-all against all regulations, but assault weapon bans present a different question. Not about disarming dangerous people, but about banning entire categories of commonly owned firearms for everyone. Many states enacted these bans after mass shootings, often defining assault weapons by features like pistol grips, detachable magazines, or bayonet mounts. Features on rifles like the AR-15, which is the most popular rifle in America, with estimates of 20-30 million in circulation. These laws typically ban sales and sometimes possession, with grandfathering in some cases, but do not retroactively confiscate existing ones in most instances. Common myth number 1. Assault weapons, are machine guns or fully automatic? No. These bans target semi-automatic firearms that fire one round per trigger pull, just like many hunting rifles or handguns. Fully automatic weapons have been heavily restricted since 1934 and effectively banned for civilians since 1986. Myth number 2. These rifles are rarely used in crime or self-defense. While mass shootings grab headlines, everyday crime statistics show handguns predominate in violent crime. But proponents argue these rifles' design allows rapid fire and high capacity, making them disproportionately lethal in attacks. Myth number 3. The Second Amendment only covers muskets from 1791. Heller explicitly rejected that, saying the right extends to modern bearable arms in common use, even if not in existence at the founding. Currently, about 10 states plus D.C. have assault weapons bans in some form. California, first in 1989, expanded after. Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, New York, and Washington. Some include large-capacity magazine restrictions, too. The recent Supreme Court non-decision in Snope v. Bruen upheld Maryland's ban via the Fourth Circuit's en banc ruling. That court said these rifles fall outside the Second Amendment's scope as military-style weapons, ill-suited and disproportionate to self-defense, and alternatively, history supports regulating exceptionally dangerous arms. But Justice Kavanaugh called that reasoning questionable and predicted review soon, citing ongoing cases in other circuits. So which 5 states could see their bans fall if the court takes a case and rules against them under Bruen's test? First, California, home to one of the oldest and broadest bans. Challenges like Ronda vs. Bonta are pending in the Ninth Circuit. Second, New York. Its SAFE Act ban faces ongoing litigation. Third, New Jersey. A challenge was heard en banc in the Third Circuit in late 2025. Fourth, Illinois. After a district court struck down its ban, it's on appeal in the Seventh Circuit. Fifth, Washington. Its 2023 sales ban has survived initial challenges, but awaits potential precedent from California or others. These are among the most vulnerable if a circuit split develops, or the Supreme Court applies Bruen strictly to common-use arms. The AR-15's commonality, more owned than many vehicle models, could weigh heavily, as Bruen emphasized, common use. What these rulings do, and do not do, is crucial. A strikedown would invalidate bans on these firearms for law-abiding citizens, but leave intact prohibitions on machine guns, short-barreled rifles without stamps, felon possession, and background checks. It wouldn't mean unregulated arsenals. States could still regulate in sensitive places or via history-consistent means. For ordinary Americans, the practical impact is real. In a state with a ban, you might face felony charges for buying or possessing what was legal elsewhere. Hunters or sport shooters might travel out of state. Home defenders might choose different firearms. This affects daily choices for millions. What do you think? Has this patchwork of laws affected your life or your views on gun rights? Share in the comments. This is for educational purposes only. I'm not giving legal advice. If you're dealing with any specific situation involving firearms laws, please consult a qualified attorney. In closing, 3 key takeaways. 1. The Supreme Court's 2025 denial in Snope left state bans intact for now, but signals from conservative justices suggest this isn't over. A future ruling could reshape the landscape. 2. Under Bruen and Rahimi, the focus is on historical tradition. Bans on common semi-automatic rifles face tough scrutiny if they're seen as lacking analogous historical limits. 3. These cases aren't about eliminating all gun laws. They're about whether specific restrictions on widely owned arms align with the Constitution's text and history. Understanding this matters because the Second Amendment protects a fundamental right tied to self-defense and liberty. Knowing the law empowers you to engage as an informed citizen, whether you support stricter rules or broader protections. Clarity here helps us all navigate a complex, evolving area of constitutional law. Thanks for watching. Stay informed, stay safe.